versus state. All right. Yep. Hey, Ms. Johnson.
Good morning, Your Honors. I'm April Johnson on behalf of Mr. Kenna. May it please the court, I would like to reserve 5 minutes for rebuttal. And may I proceed, Your Honors?
My mic was turned off. Go ahead. You're good.
Thank you, Your Honors. Your Honors, this case is in regards to Mr. Kenna, who was arrested on July 29, 2017. Mr. Kenna exercised his right to a jury trial and proceeded to trial. Mr. Kenna was ultimately found guilty of jury trial on June 11, 2019. This case is riddled with errors by the trial court. Mr. Kenna was at his house on July 29, 2017. Law enforcement officers came to his house in regards to a telephone call that they received. Mr. Kenna was confronted by law enforcement officers at his residence. He was there with a female named the cell phone of the caller, Miss Kayla Temples. Those cell phones and the evidence obtained from those were introduced into evidence in this particular case. Mr. Kenna, again, as I stated, was found guilty on June 11, 2019. With regards to this particular case, with issue 1, with regards to the admitting of evidence with regards to Mr. Kenna's resignation, that was error on behalf of the trial court. The trial court never should have admitted this evidence into evidence. The state did not lay a proper foundation with regards to this particular evidence. They indicated that it was based on a consciousness of guilt. The defense objected to this particular evidence coming in. There was a sidebar argument made very briefly. Of course, the defense argued that it was prejudicial and it was should not be admitted. At that time, the state indicated that it was being admitted to show Mr. Kenna's consciousness of guilt. The court overruled the objection and the state proceeded. Multiple occasions, Captain Castle indicated that he resigned. The state continued to ask that question multiple times in different ways to get Captain Castle to repeat that particular fact, to have the jury be able to hear that. This evidence was admitted in error because it was highly prejudicial to Mr. Kenna. The state did not lay any predicate as to how this was a nexus to the charged offense of unlawful sexual activity with a minor.
Oh, wait, the morning after he was basically caught in his room with a 17-year-old victim, he resigned, correct?
Yes, Your Honor, that
So,
morning.
what further nexus was the state required to to establish before that evidence could be admitted for the jury to consider it for what it was worth?
Your Honor, the case law that was basically cited by the appellee in this case with regards to this is something with regards to flight. With that analysis, the state should have presented some type of other evidence with regards to Mr. Kenna, such as a reason why he resigned. There are multiple reasons why he could have resigned, such as Mr. Kenna, as indicated by the trial court at his sentencing hearing, knew that he was a law enforcement officer. He knew these types of cases could have gone on for a long period of time. He knew that he was told by Captain Castle that if he didn't resign, he was going to be suspended throughout the pendency of this investigation. If he was
Isn't that standard procedure where police officers are suspended if they find themselves in circumstances where it appears they may have done something unlawful? And being in a room with a 17-year-old girl who's apparently in his bed would seem to be something that might be unlawful.
I would agree, Your Honor, that they are suspended for multiple reasons through an IA investigation or whatever the case may be. But juries do not always know this information, number one. Number two, that could have been the reason why he resigned, is because he knew that he was going to be suspended during the pendency of this investigation. And these investigations, as the court is well aware, as Mr. Kenna was well aware, as his captain was well aware, that these investigations can take a long period of time. And so can the trial period. As you can see, it lasted from 2017 to 2019. If he was going to be unemployed for 2 years, he could have resigned for that particular reason. I need to resign now because I need to get another job.
Because you are saying there are many reasons why he may have resigned, doesn't that go to the weight of the evidence rather than its admissibility?
Your Honor, I would say that would be an improper inference on part of the jury to say the reason why he resigned is because of a consciousness of guilt. Not the reason why he resigned is because he could have done these other things. When you have somebody who, such as the cases that were cited by the appellee in this case, with regards to flight, when you're fleeing.
You also have a suicide attempt case. They're not just flight cases.
There is a suicide attempt case, that is correct. When you attempt a suicide right after when you are getting charged with a particular crime, a very serious crime, those cases are very particular with regards to a case in which you are having a very, I guess, serious reaction.
So at the bottom of it, you want us to accept the proposition that the trial judge abused its discretion by allowing this evidence.
Absolutely, Your Honor. The appellant's position is the trial court absolutely abused its discretion in allowing this evidence to come in.
So no reasonable trial judge would have allowed this evidence.
I would say that is correct, Your Honor. That this does not go to consciousness of guilt whatsoever. With regards to Mr. Kenna's issue 1, as I indicated, this does not go to consciousness of guilt.
Well, let me ask you this, Ms. Johnson. If it doesn't go to consciousness of guilt, then what's the prejudice? And you can sort of shoot yourself in the foot with your own argument. If it's so irrelevant, if it's so meaningless, then why is the probative value substantially outweighed by the danger of unfair prejudice?
Because the prejudice, Your Honor, is because the jury heard literally over and over and over and over again. You can see it in Captain Castle's testimony. The state intentionally asked Captain Castle. So he resigned, yes. So after you spoke with him, he resigned, yes.
But so what? If it's not probative of anything, so what if the state wasted its time asking a meaningless question over and over?
I'm not saying that it's absolutely that the jury's not going to take it as that, because the state did exactly what they wanted it to do. When they hear,
And it's
when
probative of that. If it's susceptible of that interpretation, then it's probative of that.
I would disagree, Your Honor. I would say that the jury is going to absolutely take it that way, because when you hear that as a jury member, you're going to sit there and say, why do they keep repeating this one thing over and over and over and over and over and over again? The problem is that it's prejudicial to Mr. Kenna because they laid no foundation whatsoever as to how that piece of evidence should have come in. They laid no foundation as to Mr. Castle, Captain Castle, saying, okay, this piece of evidence is going to come in because of this. Just like you have to lay a foundation to admit pieces of evidence. That's the same exact reason why that should have, Captain Castle should have laid a foundation as to how that piece of evidence fits to the nexus with regards to his count one. With regards to issue 2, the trial court definitely erred in limiting the cross-examination of Detective Jones with trial counsel with regards to saying that they open a door to the appellant's previously suppressed statements. That is absolutely false. The case, excuse me one second. The case law is very clear with regards to opening the door. It is a very limited area of law with regards to when an appellant opens the door to his previously suppressed statements. Mr. Kenna did not testify in this case. Mr. Kenna did not have somebody testify on his behalf in this particular case. The trial court flat out shut down trial counsel when she attempted to cross-examine Detective Jones in regards to the DNA in this particular case.
Except the trial court didn't really flat out shut down trial counsel, right? Because trial counsel was still allowed to ask if any DNA evidence had been collected.
Right, trial counsel.
So what is the difference between the question that counsel was allowed to ask and the question that counsel's apparently wanted to ask? Why did that not accomplish what trial counsel wanted to accomplish?
Because the judge literally allowed her to ask only one question with regards to the DNA.
Well, if she had asked the questions that she proffered, how would the state not have been allowed to inquire as to the reasons why the DNA wasn't collected, which would go straight to McKenna's confession or Kennett's confession?
Your Honor, I would completely disagree with you. It would not go to Mr. Kenna's confession because in this particular case, Mr. Kenna was not testifying, and as you could see,
But he confessed the morning of the event.
Yes, Your Honor, he did, but
and that was the statement that's why the state didn't pursue a DNA kit, right?
No, Your Honor, that is not why. As you can
How do we know that? I mean, isn't that exactly what the detective said in the proffer?
In the proffer, Detective Jones said there are multiple reasons why they did not collect the DNA. And
Well, his answer when he said, there are multiple reasons, when the question was, what was it? I think the reason is the fact, and the detective answers, when I spoke with Mr. Kenna, he admitted the allegations and the fact at that time. So why would there need to be a DNA?
Right, and Detective Jones also indicated that the other reason why is because of the time that had passed in between the alleged offense and the
Well,
collection.
but once the
that would have been
defendant
collection
has
time.
admitted it, then why do we need to subject the victim to a rape kit? I think that was the state's point, and that was what the trial judge accepted. And as Judge Rothstein-Uiken points out, your trial counsel got in the fact that DNA wasn't collected, so there was no DNA evidence, which was really the point, wasn't it?
That was
From a defense standpoint.
part of the point. However, the victim's credibility in this case was very much at issue. She had already at multiple points given multiple different statements to law enforcement as to whether or not this event had actually happened.
Well, was Mr. Kenna's credibility an issue when he confessed?
But that evidence with regards to Mr. Kenna had already previously been suppressed. That's the particular
But
issue.
that's the reason why the rape kit wasn't done.
That's not the only reason why the rape kit was not done. So that's what our main issue is if that were the only reason, if that were the absolute only reason, then that might be a possibility, because that might, and I'm only saying might because we do not know, because that's not the facts before us today. But if that were the only reason, that might present a different argument here today. But that is not the only reason why. The detective specifically said there are multiple reasons. One of the reasons is because he confessed. The other reasons is because of the time that had already lapsed. That in and of itself is also probative. How much time had lapsed? What did the victim tell you with regards to the time that had lapsed? And getting into those specific facts. Why wasn't the DNA collected because of the time that had lapsed? Isn't that a normal standard procedure with regards to collecting bedding, sheets, comforters, pillowcases? That is normal standard procedure in a typical case like this when you have a alleged victim.
So was your point that the police didn't do their job? Or was the point that no DNA was collected? I mean, what was the point of that question? Because if the point was that there was no DNA collected, then that was clearly established. If you're trying to imply that the police didn't do their job, that's misleading.
Well, I believe that the answer to that is kind of one and of the same. No DNA was collected in this particular case.
And that is relevant to the victim's credibility. There's just no DNA. We don't know if none was collected. You could have asked, was there any DNA? There's no DNA evidence. Maybe
Right.
some was collected, there wasn't a match. And by asking a more general question, I think it actually would have inured to the defendant's benefit. But so if you're just trying to question the victim's credibility, why haven't you done that by establishing, we don't have any DNA evidence to support this?
Yes, but there's more questions that could have been asked by trial counsel with regards to Detective Jones, but trial counsel was completely shut down by the trial court. The trial court said absolutely none. There's only one question that you can ask. But when Detective Jones said that there's multiple reasons, the trial court should have allowed the trial counsel to investigate what those other reasons could have been. The trial counsel could have asked other questions about whether or not the victim was willing to submit to a sexual assault kit. If she's not willing to, that's indicative of something that is maybe her lying again, because she had already told us that she was lying previously when she told
She testified, right?
She did testify.
Was she asked that question?
She was not asked that question.
Okay, Ms. Johnson, you're into your rebuttal time. And I apologize, I had
It's okay.
knocked my clock, made it stop. So I don't know how far you are into your rebuttal time, but I'm confident you are.
Thank you, Your Honor.
Mr. Cannon?
Morning, Your Honors. May it please the court, my name is Jonathan Tannen with the Attorney General's Office representing the state of Florida. On the first issue dealing with Mr. Kenna's resignation from the Winter Haven Police Department, the trial court did not abuse its discretion by admitting that evidence. The testimony at trial established that he was arrested earlier that morning, or that he was caught in his bedroom with the 17-year-old victim undressed in his bed. Later that morning, a captain with the Winter Haven Police Department spoke to the defendant and gave him the option to either, or rather told him that his options were to resign or be suspended pending termination, and he chose to resign. Under these circumstances, the jury could properly view this as evidence of consciousness of guilt. The appellant's argument that there was no nexus established between the offense and the consciousness of guilt evidence is not correct in this case. The cases dealing with consciousness of guilt typically refer to a circumstance where the defendant was not aware, or there was no evidence the defendant was aware that he was being investigated for a criminal offense at the time he took the action at issue. In some cases, that's flight. In one case, that's suicide. In a case this court recently addressed, it was that the defendant had moved to Pennsylvania sometime after the murder. And in all of those cases, the common thread is that there was no evidence the defendant was aware he was being investigated for a criminal offense. And that simply isn't the case here. The defendant was caught red-handed, as it were, with the victim in his bedroom late at night. She was 17 years old. And the jury could reasonably infer that he resigned because he knew he had been caught and he knew he had no other option. So the state would submit, first of all, this evidence was relevant. Secondly, there was no unfair prejudice as a result of this evidence. This was not the type of evidence that would have inflamed the jury or appealed to the jury's emotions or referred to some other bad act committed by the defendant. The resignation was either relevant because it related to the criminal offense or it was irrelevant. Either way, there was no unfair prejudice as a result of that evidence. Additionally, the state would submit that even if the trial court had abused its discretion, any error was harmless in light of the other evidence that was submitted in the case. First and foremost, we had the victim testify that she did have a sexual relationship with the defendant. Obviously, the defense challenged that based on her initial denial that they had such a relationship, but the jury heard significant other evidence establishing that they did have a sexual relationship. We had the testimony from the defendant's roommate and ex-girlfriend, Ms. Temples, that she was in her bedroom and she heard the defendant and the victim in the next room making sexual noises, essentially. We had the testimony of Officer Absolu that when he knocked on the defendant's bedroom door and the defendant opened it, the officer saw the victim in the defendant's bed with a sheet pulled over her, and the defendant asked if the girl could get dressed. Finally, we also had the text messages between the defendant and the victim, which referred very explicitly in several cases to prior sexual acts between them. So even if the trial court had abused its discretion, which the record shows it didn't, any error would have been harmless on the face of the record. With respect to the second issue, the cross-examination of Detective Jones, again, there was no error by the trial court. According to the record, the defense was not prevented from asking any question that it wanted to ask. The sidebar discussion had to do with whether, according to the trial court's concern, the defense was going to be arguing that the police didn't do their jobs in some way. And the trial court expressed the opinion that, well, if that's the argument the defense is going to make, then that's going to be misleading, because the reason they didn't ask the victim to do a rape kit is because the defendant had confessed and he was not disputing that he had a sexual relationship with the 17-year-old girl. And defense counsel responded to that I wasn't planning on arguing that they didn't do their jobs properly, but lack of evidence is a proper basis for argument. And the trial court agreed with that. It allowed the defense to ask Detective Jones whether any DNA evidence was collected in the case. He agreed there wasn't. And the defense argued that point in closing argument. So under these circumstances, first of all, to the extent the defense is arguing that they should have been allowed to ask some questions that they weren't allowed to ask, any error is unpreserved because that argument wasn't made below. Secondly, the trial court didn't abuse its discretion with respect to its resolution of the issue, particularly since everyone seemed to be on the same page as far as what the defense wanted to establish, and that evidence was ultimately admitted. And finally, again, any error is harmless for the exact same reason that there was no evidence that was material to the defense that was ultimately kept out. So as far as issue 2, again, there's no error on this record. I know issues 3 and 4 in the initial brief weren't discussed during the appellant's arguments. Does the court have any questions about either of those issues? Okay, well, if the court has no further questions, I will rely on the state's answer brief for any further arguments, and the state requests that the judgments and sentence be affirmed. Thank you.
Thank you, Mr. Tannen. Ms. Johnson?
Yes, Your Honors. Just briefly, with regards to the harmless error argument that the state just made, we would argue that it is not harmless error. The government hasn't met its burden with regards to that. I apologize for not getting to my third and fourth arguments. I did run out of time, so I'll just briefly touch on that. With regards to issue 3, there was insufficient evidence on the record to establish the appellant's age. The appellant's age was only brought out by Ms. Temples, who indicated that he was 39.
There was evidence elicited that showed that Mr. Kenna has that one of his children was a classmate of the victim, correct?
There was said that she went to school with her, Your Honor, but there was no evidence as to how old she was.
Well, they were in high school, right?
Yes. What?
So the friend was at least 14, 15 years old.
Possibly,
correct?
yes. Correct, Your Honor.
And the age that the threshold that had to be hit here was 24.
Yes, Your Honor.
So there aren't that many 9-year-olds that have run around and fathered children who are 15, 16 years old, are there?
I don't know, Your Honor. I know that there are, unfortunately, in our day and age, there are kids that are having younger kids at younger ages.
But Ms. Temple's testimony by itself was sufficient, correct? Because we have to take the evidence in the light most favorable to the state at this point. And also, you never move for a judgment of acquittal at trial on the issue. So it's really a non-issue, isn't it?
No, Your Honor, I would say I would completely disagree with that. Ms. Temple's testimony, number one, is hearsay, and it is circumstantial evidence at best.
Ms. Temple lived with him in a romantic relationship for a number of months. How is her knowledge of his age hearsay?
I would say that people lie about their age every single day. People, unfortunately.
You never objected that it was hearsay, though, did you?
No, the trial counsel never did object to the fact that it was hearsay.
And so we have to take it in the light most favorable to the state.
And in light most favorable to the state, she did testify to the fact that he was 39 years old. That is the only piece of evidence. As the brief indicates, the case law is abundant with regards to what type of evidence is usually sufficient for admitting age.
However, was there evidence about how long he had served in the military, right, before he became a police officer?
He did serve in the military, yes, Your Honor. But people join the military at the age of 17. So there's,
Was there any indication in the record about how long he had been an officer?
No. And I don't even believe his service record came into the actual record. And with regards to the JO8 argument, there's case law that just came out at the beginning of this month that indicates that failure to move for a judgment of acquittal is inefficient and ineffective assistance of counsel on the face of the record.
And the jury could see the defendant, right? He was sitting right there in front of them.
They could, Your Honor, they could see him. So I would submit that that's basically a stacking of inferences. You have two pieces of evidence if you want to argue that. One, that she says he's 39, and two, the fact that the jury can see him. That's only two pieces of things that you're saying.
And the fact that the jury knew that his child was a classmate of the 17-year-old victim that they also saw.
they saw the alleged victim. Yes, they did not see his daughter. So I would argue that that is insufficient to say that we know how old his daughter is, because we have no idea how old his daughter is. His daughter could have jumped grades. His daughter could be, you know, a lot younger than the alleged victim in this case. We have absolutely no evidence as to how old his daughter is. There is no proof on the record as to how old his daughter is. So we cannot use that as a basis to say they knew how old his daughter was because she's a friend of the victim. That is absolutely insufficient to say that is circumstantial evidence that the jury can rely on, because that is not.
The jury can rely on their own perceptions of his age.
I would say that they can look at him, yes, but that in and of itself alone is insufficient. And that plus the only evidence with Miss Temple saying that he's 39 years old just because she lived with him for a few months is insufficient evidence. The case law that the appellant provided to the court shows the abundance amount of evidence that the state has to provide in order to prove the appellant's age is abundant. It's not just two pieces of little evidence to show that the appellant's age is over the threshold of 24 years old. It's
Ms.
not.
Johnson, your rebuttal time is up.
Thank you, Your Honor.
I didn't
Your Honor, for your
stop my
time
clock
today.
this time. Okay, thank you both very much.
Thank you.
Oops.